This is the first of 2 lectures on self-induced intoxication. In this lecture, I discuss the circumstances under which self-induced intoxication can negative the fault requirement for a given offense. Let's start with objective fault offenses, because this is pretty easy. Remember that in Creighton, Madam Justice McLaughlin was clear that the reasonable person simply does not engage in regulated activities while intoxicated. It therefore follows that one's self-induced intoxication is irrelevant in the context of objective fault offenses. Quite simply, the fact that one was too drunk to adhere to the standards of the reasonable person can provide no basis for an acquittal. Matters, of course, get somewhat trickier when we turn to subjective fault offenses. Intuitively, of course, the fact that one had a bit too much to drink or had consumed drugs ought to be relevant to whether or not one turned one's mind to some relevant circumstance or consequence. And to that extent, one would expect that one could adduce evidence of one's self-induced intoxication by way of negativing the fault requirement for a subjective fault offense. Matters, of course, are not quite so simple. Whether or not one can consider self-induced intoxication as a basis for negativing subjective fault will, in the end, depend on the kind of offense we're talking about. In particular, we have to introduce a distinction that so far we haven't needed to talk about in these lectures. And that's the distinction between general intent offenses and specific intent offenses. Where we are dealing with a general intent offense, one's self-induced intoxication simply cannot negative fault. Period, full stop. Where, on the other hand, we're dealing with a specific intent offense, it can. Now, this distinction between specific and general intent is a distinction devised specifically to cope with the problem of self-induced intoxication. It's the only reason we care about this distinction. In principle, the distinction between specific and general intent offenses is conceptually drawn on the basis of the level of mental acuity required to commit a given offense. Some offenses require only an intention to commit a particular act, say assault, sexual assault, which require proof only of an intention to apply force. Other offenses require proof of an intention to commit a particular act for a particular purpose, or in the knowledge of some state of affairs, or in the knowledge that some consequence may ensue. For example, murder or robbery. Now, the former we describe as general intent offenses, because these require proof of relatively little mental acuity. The latter we describe as specific intent offenses, because this requires proof of a somewhat more complex line of thought on the part of the defendant at the relevant time. The supposition is that with respect to general intent offenses, those offenses requiring relatively little mental acuity on the part of the defendant, that the mental acuity required is so simple or basic that even a heavily intoxicated individual could reliably achieve it. barring intoxication to the point of an automatism, which we'll talk about in the next lecture. By contrast, the mental acuity required for specific intent offenses is sufficiently complex that one's self-induced intoxication, it's said, can call it into question. Now, at risk of stating the obvious, the question is whether or not this offense with which the defendant has been charged is one of general or specific intent, and not whether this offender deserves to be punished. We are engaging here, the focus here is very much on, again, statutory interpretation. We are asking whether or not this offense with which the defendant was charged is itself one of specific intent or general intent. If we conclude that it is an offense of specific intent, then evidence of the defendant's self-induced intoxication may be admitted by way of negativing fault. If it is an offense of general intent, then evidence of the defendant's self-induced intoxication is simply irrelevant. Now, where precedent has already determined that a given offense is one of general or specific intent, we can, happily enough, regard the matter as settled. But where precedent has not resolved the matter, we need to look to two considerations. First, what mental element has been set out by Parliament for the offense in issue? And second, would it be contrary to public policy to characterize the offense as one of specific intent and therefore allow the accused to rely upon a defense of self-induced intoxication? On the first point, the mental element of the offense in issue, we might ask questions like, has Parliament made ulterior purposes part of the offense? So, for example, the offense of assault with intent to resist arrest. There it isn't enough to establish an intention to apply force. One must also show an intention to resist arrest. That suggests that proof of an ulterior purpose is required and that greater mental acuity on the part of the defendant is necessary. And that, in turn, we will be readier to infer that Parliament took the view that, yes, self-induced intoxication can indeed negative fault for that offense. What other sorts of mental elements might demonstrate that Parliament thought that greater mental acuity was required? Well, maybe the offense in issue requires an intention to bring about certain consequences. For example, the offense of murder. We might ask questions like, to what extent has Parliament imposed additional knowledge components? So to what extent does one need to know of certain circumstances in order to commit this offense? To the extent those additional knowledge components are there, again, greater mental acuity. Now, if an examination of the mental element of the offense doesn't provide us with a clear signal as to whether or not Parliament intended this offense to be one of specific intent or general intent, then we're going to need to turn to that second stage, policy considerations. What sorts of questions are we asking when we consider public policy? Well, we need to keep in mind that it would be absurd to suppose that Parliament intended to devise an offense for which self-induced intoxication could be a defense, when the offense itself is typically or frequently committed while in a state of intoxication. Why would you make it an offense to engage in this course of action, which people typically engage in while drunk, and then say in the same breath that if you're drunk or high, that we will acquit you? The answer is that Parliament wouldn't do that, or we wouldn't certainly expect it to. And so, to the extent that the offense in question is typically associated with, as it were, intoxicated offenders, we're going to be more likely to proceed on the basis that Parliament didn't intend for self-induced intoxication to negative fault. Furthermore, we might consider whether there is a lesser included offense that is one of general intent. If so, there's less risk that self-induced intoxication will lead to an outright acquittal, and so less reason to regard the availability of this negative defense as absurd. Now, just to be clear, this public policy line of argument isn't supposed to override the analysis of the mental element that we did in step one. That, it's quite clear, is meant to drive our analysis for the most part. All of this talk about public policy is really by way of settling the matter in cases of real ambiguity. Now, the Supreme Court applied this approach to determining whether or not an offense is one of specific or general intent in a case called Tatton. And Tatton focused on section 434 of the Criminal Code. And that provision states, every person who intentionally or recklessly causes damage by fire or explosion to property that is not wholly owned by that person is guilty of an indictable offense. And in Tatton, the court looks at the language of section 434 and finds that, well, look, the level of mental acuity required to intentionally or recklessly cause damage by fire or explosion is pretty minimal. One need only turn one's mind for a moment to the risks associated with a fire or an explosion. So fairly minimal degree of mental acuity. And that by itself, the court in Tatton suggests, is enough to lead us to conclude that this offense is one of general intent, and that therefore evidence of self-induced intoxication is really gets you nowhere by way of exculpation. In Tatton, Mr. Justice Moldaver, writing for the court, states, "I have difficulty seeing how intoxication short of automatism would prevent an accused from foreseeing the risk of causing damage to someone else's property by fire. Complex reasoning is not required to recognize the danger. Thus, preventing an accused from advancing the defense of intoxication does not transform recklessness into an objective inquiry. Rather, it recognizes the fact that intoxication short of automatism will not deprive an accused of the minimal intent required for this crime." Now, as I say, the court is able to reach this conclusion in Tatton essentially on the basis of the mental element set out in section 434. However, the court's also clear that had it needed to consider policy factors in determining whether this offense is one of general intent or specific intent, well, it wouldn't have changed the outcome, because damage to property is often associated with alcohol abuse. Now, Tatton, and indeed the entire distinction between specific intent and general intent, to the extent that we are relying on this distinction to determine whether or not criminal defendants are even entitled to adduce evidence of self-induced intoxication and attempt to negative fault by adducing that evidence, is highly controversial. And we can see why this is all controversial just by even turning to the facts in Tatton itself. In Tatton, our defendant is very drunk. He places a pan with oil on the stove, sets the burner to high, and then leaves the house to go and get some coffee. He returns 20 minutes later and finds his house on fire. The trial judge concludes that this offense is one of specific intent. So, contrary to what the Supreme Court ultimately found, considers the defendant's state of intoxication and acquits, finding that the defendant's state of self-induced intoxication was such that he never even considered the possibility, never even considered the risk that his conduct might cause any damage to property. Now, we know, as I say, that the trial judge was wrong to find that this offense was one of specific intent. Following the reasoning of Mr. Justice Moldaver in Tatton, we now know that this offense is one of general intent. And so we might think, no surprise that the Supreme Court orders a new trial. But wait, think about this for a moment. So we're going to have a new trial, and what's going to happen at the new trial is that the defendant whose self-induced intoxication earned him an acquittal at the first trial won't be able to adduce evidence of his intoxication at the second trial. And the trier of fact will be unable to consider even the possibility that the defendant lacked requisite fault on the basis of his drunkenness even though at the first trial, it was found that that state of drunkenness was enough to negative fault. So we're actually, in a sense, in a very real sense, depriving the defendant of a defense that had succeeded at the earlier trial. And what we might well wonder is, who cares whether or not an offense is one of specific or general intent if the defendant's state of self-induced intoxication actually negative fault? We may well ask whether or not it's fair to assume that non-extreme intoxication is never a factor capable of undermining the minimal degree of awareness or intent needed for a general intent offense. We might well ask whether it's reasonable or fair to deny all defendants of the opportunity to at least make the argument in a given case in which they've been charged with a general intent offense. Now, in a case called Bernard, Mr. Justice McIntyre had an answer for this. And his answer was essentially, look, if you've managed to get yourself so drunk or so high that you are unable to attain the minimal level of mental acuity needed for a general intent offense, well then, just getting yourself that drunk or high is itself blameworthy. For his part, Chief Justice Dixon thought that all of this was seriously problematic on a charter level. By depriving the defendant of the opportunity to argue that self-induced intoxication negatived fault in the context of general intent offenses, effectively, what Chief Justice Dixon claimed is that this transforms general intent offenses functionally into absolute liability offenses. It makes it possible for criminal defendants to be convicted not because they actually had turned their minds to this or that risk, but because they simply lacked the opportunity to present evidence capable of casting doubt on that. So far, I've discussed the extent to which evidence of voluntary intoxication can be used to negate fault. We've seen that it can, but only where the offense in question is one of specific intent. In the context of general intent offenses, evidence of voluntary intoxication simply cannot exculpate. Suppose, though, that the claim is not just that one's voluntary intoxication removes fault. Suppose that one makes the more radical claim that, as a result of voluntary intoxication, one lacked the ability to engage in voluntary conduct at all. Let's recall a few basic propositions from earlier in the course. First, recall that the criminal law does not attach liability to involuntary acts. As an interpretive proposition, we presume that criminal offenses address themselves to voluntary actors only. But as a constitutional matter, too, we take the view that actors who lacked the capacity to control their own actions cannot be punished. Second, recall that the Supreme Court has held that, at common law, defendants who were in a state of automatism at the relevant time cannot be convicted for behavior undertaken during that time, even though they did not suffer from a disease of the mind within the meaning of Section 16 of the Criminal Code. Now the question is, must a person who achieved a state akin to automatism as a result of the voluntary consumption of an intoxicant also be acquitted on the basis that he or she was incapable of voluntary conduct at the relevant time? Alternatively, do we adopt the same approach that we take when assessing whether voluntary intoxication can affect fault? That is, do we say that it matters in the context of specific intent offenses, but not general intent offenses? The leading case on this question is the Supreme Court of Canada's decision in Davio. And ultimately, a majority in Davio held that in cases of extreme intoxication, in which the defendant is in a state akin to automatism, such that he or she was incapable of voluntary action, the defendant must be acquitted whether or not the offense is one of general or specific intent. In reaching that conclusion, the majority rejected an argument that was used to sustain the distinction between general and specific intent in Bernard. In Bernard, recall, Mr. Justice McIntyre defended the idea of general intent offenses, the idea that it was okay to remove consideration of voluntary intoxication in a certain class of subjective fault offenses, on the basis of substituted fault, even if the defendant's voluntary intoxication was such that he or she lacked the minimal mental acuity needed to commit a general intent offense, he argued. It was nonetheless fair to convict him or her because the very decision to become that intoxicated was itself criminally blameworthy. Now, the question raised by this line of reasoning was, in effect, whether there could also be what we might describe as substituted voluntariness. So, assuming that the defendant's intoxication reached such a pitch that he or she was incapable of voluntary action at all, could we nonetheless treat the defendant's conduct as voluntary on the basis that the initial decision to reach such a state of extreme intoxication was itself voluntary and blameworthy? In Bernard, Madam Justice Wilson balked at this idea. It was one thing to convict a defendant on the basis of substituted fault, but to convict someone who was incapable of voluntary conduct altogether was quite another matter. And in the end, a majority in Davio took the same view as Madam Justice Wilson in Bernard. The majority in Davio noted that voluntary intoxication, even extreme intoxication, is simply not a crime, and that it's therefore deeply problematic to say that such conduct is so blameworthy that it can obviate the need on the part of the Crown to show voluntariness. Furthermore, there's not such a close connection between the consumption of drugs and alcohol and the commission of assault or any other general intent offense for that matter, that the decision to engage in the former can be effectively treated as a decision to engage in the latter. At best, extreme intoxication is merely a facilitator of violence. The bottom line is that following Davio, where a defendant could satisfy the court on a balance of probabilities that he or she had achieved such a state of extreme intoxication that she was in a state akin to automatism, that this must operate as a defense to all offenses, whether they're offenses of general intent or specific intent. Now, Davio was a highly controversial decision, and it caused a public uproar. And so, following that decision, Parliament enacted Section 33.1 of the Criminal Code. Section 33.1 can lead to results that are, to put it mildly, deeply troubling. Take, for example, the case of Bouchard-Lebrun. There, the defendant consumed ecstasy and as a result suffered from toxic psychosis. Now, this had never happened to him before. And while in that state, he brutally attacked two people and was charged with aggravated assault. Aggravated assault is a general intent offense. And so the defendant couldn't argue that his state of intoxication negatived fault. All he could argue was that his extreme intoxication, his toxic psychosis, had undermined voluntariness. Now, this was a plausible claim. Two psychiatrists agreed that at the time of the attacks, the defendant was unable to distinguish right from wrong. And so the defendant claimed that he was in a dissociative condition. Now, the Supreme Court found that the defendant couldn't claim to have been NCRMD per Section 16 of the Code. Why? Because the defendant's condition was caused by the consumption of the ecstasy. And so this was, almost by definition, an external cause, not an internal one. Moreover, there was no real prospect here of continuing danger, since it had never happened before to the defendant entering into this state of toxic psychosis, and to the extent that his condition in this case was caused by the ecstasy, well, he could simply avoid taking ecstasy in the future. So there was no disease of the mind, and therefore the defendant couldn't be found NCRMD. Here's the thing, though. Nor could the defendant be acquitted on the basis of non-mental disorder automatism. Why? Because of Section 33.1. It precluded the defendant from claiming lack of voluntariness resulting from his state of extreme intoxication. So what do we have here? We have a situation in which the defendant can't argue lack of general intent. He can't argue that he's not criminally responsible by reason of mental disorder. And he can't argue non-mental disorder automatism. So what are we left with but conviction? Yet how can that be right if the defendant was incapable of voluntary action at the time he engaged in the attacks? Following Bouchard-Lebrun, the Supreme Court of Canada faced a great deal of criticism for refusing to address head-on the constitutionality of Section 33.1. And it was not until very recently, when the Ontario Court of Appeal decided Sullivan and Chan, that we finally had an answer as to whether or not Section 33.1 passes constitutional muster. Now, Sullivan is a decision of the Ontario Court of Appeal, so it applies only in Ontario. But it's an important ruling, and one can expect it to be highly influential. So that's all on voluntary intoxication and the extent to which it can negative either fault or voluntariness. See you next time.